Legal protection.
We'll take up. We'll take up.
She has been trying first.
No. We'll take up.
May I please? This matter denotes, I was asked to reverse an amount of 4 lakhs, 39,000 amount, where Annex 1.
Order under section 74.
No, they have initiated the section. What has happened, Lord? In my reply, I said that at Annex 2. I've said that page 21. Page 20, they tell me on 12th of July 2024 that you reverse 4,39,970. Then I write to them on 17th of July that I've already reversed this particular amount in the 3B returns. In the month, the returns for the month of April 2024 amounted to 264,342. And in the month of June, 172, 120. And I annex my 3B returns also.
No, you have said that you have more credit than what you have.
And simultaneously, I reverse this amount. If the Lordship would see, I have annexed the 3B annexed at page 23, the relevant portion of the
Yes. When you did it?
Sorry, at page 23, the third column, B, ITC reverse.
No, I understand.
So I have reversed that.
When?
In April 2024, you'll get it at page 22. No?
That is a date of ARN is 1905. There's a 1905.
Pardon?
It is a 1905.
No, yes, no. 19/5/2023, I reversed it in by April.
Not in April,
No,
but in May.
No,
but for the month of April, I filed my return.
Yes.
And if the Lordship would just turn over the page, the Lordship would get it at column number B, ITC reverse. Left hand side, the Lordship would see. The third,
Yes.
then this 2,64,342. Then the balance amount at page 26. Same thing, Lord, I reversed it in June. You can get the date at page 25. 26, I reversed it 1,75,120. So the entire amount of this, what was told to me in July, has been already reversed by me in my monthly returns in April and June.
Now he is demanding interest.
Now he is demanding my lordship in a very clear and peculiar order, Lord. Then he gives me a personal hearing. In the personal hearing also, I reiterate my entire grounds. And I tell them, and I also annex Lord these documents. And I tell him that I have already reversed it. Page 55, the Lord could see. In my personal hearing, I have also told the same thing, and I have already reversed it, Annex 4. Then in the order, if your Lordship would see, the order begins, my Lord, at Annex 5, page 56. The relevant portion would be page 67, Lords. Paragraph 6. Discussion and findings. Lordship got it? Page 67.
67.
67. That's the relevant portion of the order in original. I have, Lordship got it? I have carefully gone through the case record, including the allegations contained in the impugned.
Not satisfactory.
Not satisfactory. Further, on verification of
So not to reverse.
no notice ITC has been reversed, though the return hence that the returns hence and the reply submitted.
And I say that there is no document which to ascertain that it has been reversed.
Next, in my first reply, Lord, when I was asked to pay,
Even then it is there with him.
it is there with him.
Then you have closed. This is absolutely a closed mind. Once he has reversed, he has done it much earlier, and this order was passed on 3rd of February, and this was already reversed much month before.
7.0. 7.0.
What are you doing?
7.0.
And he reads.
And the Honorable Supreme Court judgment is against this. He should be in contempt now.
What is this he is
Have you
doing?
seen Honorable Supreme Court judgment in service tax? Are you aware?
No.
No, not aware. He has enclosed it.
Where is
It is there.
Northern operating next step also.
Where is that?
Page 77, if the Lordship could see.
What is the principle decided there? Merely non-payment of tax would not attract fraudulent activity or willful default unless you have material. That is the principle. That is common principle.
What is this going on? This is not expected. You have to be very generous. You have to be very, with the open mind, you'll have to decide. Don't mean that it's a one-way traffic. When these documents are there, it is also available on the portal. You can just go and click the portal whether it has been done. On 3B was already uploaded. It's not that it was not. Then why you did not take into account?
Perhaps Kiran Stone Crusher also he is not aware. He will say you are not aware. Kiran Stone Crusher. What is the principle laid down by this court?
And
Even if-
this part of the Fraudulent Act, Section 74 is invoked.
I have to verify whether this reversal has been made for this.
He has given a document, one verification. Can you deny? They will be in contempt. And they will expose themselves for a criminal prosecution.
Sir, is it your case that
They use those documents fraudulently.
So is it your case that he has not filed returns for April and June?
Manoj, that has been filed.
And these are not the return. Is it your facts?
Manoj, reversal has also been made, but the reversal related to this transaction or not, that has to be verified, Manoj.
This is
What is 4 lakhs is the in total, and it is he has reversed the in total, that entire amount. How can you take an instruction that it is relatable to this or not relatable to this?
Para 7.
Manoj, I've-
Para 7, sir. That is 12 days.
Recently, Honorable Supreme Court in November 2025, Honorable Pardiwala, Justice Pardiwala, has passed a judgment also on the same issue. BHP boilers versus the Commission of Central Excise. That you can say
Please
that.
give the numbers.
Yeah, not well said.
What is this going on?
So you are, instead of making hassle-free interface with the assessees,
Sometimes you're
Not
not
surprised.
very well the
Often.
department.
No, difficulties is not there. Difficulty, the only thing is the mindset. It's not a difficulty, it's a mindset. Unnecessarily harassing a SSE who has done
The
everything.
officers knows very well that this order will not be sustained.
So what? And they will go on committing a mistake. No, that is not there. If that is the scenario, I will dictate this judgment. I dictate this.
Section 6, they are throwing into the dustbin. Section
I will.
6
will.
is not there.
And I will say that if that is the scenario, then I will make certain observations.
Proper things here.
No, this is one of the, I would say, the greatest example, a classical example of these natures. They will not consider the judgment of the High Court. They will not consider the judgment of the Supreme Court. They will go off their own. This is not expected.
1 week next time.
No, sir, 1 week. 1 week. That's giving a premium to you. There's no answer to it. The documents are there.
Yes.
Only thing is, if they have used that particular fabricated document or a false document, definitely they will expose themselves to a criminal liability. There's no doubt about it. If you come and tell us that this is a fraudulent document, we will take them to task. But these documents are all downloaded. It is already there in your portal.
Yes.
Everything is there available to you.
Yes.
Even in the income tax, when you file a return and they claim that the TDS has already been deposited, will you not go and verify the SSE has claimed from 26 AS? Will you not do that? You just go and verify that it is there or not. Why not? Before embarking this journey, and then will you not just make a cross check? Once
He has deposited money, penalty of the equal amount again,
Yes.
and interest. What is this? Under bona fide, he has deposited, reversed the entire thing. He has balance with him. And now penalty and interest. Where from? Let him pay from his salary, this interest.
this was a case of that he was corresponding. The buyer or the seller has not deposited the
It was his genuineness was doubted.
true. So genuineness was doubted because your genuineness cannot be doubted.
My
You are a bona fide
statement for that person.
you are a bona fide commercial person. You are transacting it. You have raised you have paid the GST, you are entitled to a ITC. Whether the other counterpart has done anything or not, that is not within your knowledge. And the moment it is brought to your knowledge, you have reversed. What more bona fide a SSC can do? He does not have that particular, the mechanism to inquire whether it is done or not done. Nobody can enter into another's, the account. They have no access. That's a privacy which is maintained. But the officer, they have an access. This is something which.
Next week, corresponding income tax has not started. Huh? In some of the matters I have seen, correspondingly income tax department has also proceeded.
More than 50 lakh there.
Acha.
It's not.
In both the matters, next week.
No. If I write, if I dictate, I will dictate. I know how to dictate it. Give me that judgment of Justice Madhugala.
Sir,
We will go to the nuances of the alternative remedy or something will not go into this. It's an apparent and a blatant violation of the mandates given by the Supreme Court, by the High Court, everything is so absolutely visible.
sir, it is your instruction number 5 of 2023, dated 13th December 2023, referred. Attention is invited. It is your instruction, your departmental instruction. Attention is invited to the first sentence. Attention is invited to the Honorable Supreme Court's judgment dated 19/5/2022 in the case of Northern Operating System, so on the issue of nature of secondment of employees by so and so. Then this judgment entirely based on fraud and 74. And Fiat India is also the same. And you are saying that you do not know.
I'm sorry.
It is your circular, your instruction manual.
Well, if I write, then I will write in the different one.
Then let them appear before the AO.
Appear before the
What are you talking about?
I mean,
Is there such a case there? It should not wait for even a second.
giving handle for him to further
Commit of non.
deep into and to search out some other things which are not there. Huh?
No, he will not be able to search out any of this. He has to concentrate within a folds of the so-calls. You can't go beyond that.
No, another show he will give.
So that is why it's fresh call of action. It's always there. But he has to concentrate this case. Yes, both matters are like this.
Of your department,
Only
you are inside the
Assessment here or an amount is different.
amount different.
That
is 4 lakhs here.
Same financial year.
10 lakhs it's
Same financial year.
different as different interest.
Oh, different.
but transaction is similar.
Same.
They have reverse.
Yes.
And interest and penalty.
Here it is.
And interest and penalty 74.
Yes, fine. To 17 to the.
You are not sparing even a baba.
Same period for both the cases, August 17 to December 17. Parties are different and amounts are different.
Officer is same.
Office is the same.
If he pays from his pocket, at least interest part, to restore his fees, at least. secure his face.
The date of order, that is 3rd February, the 4th February, the second. Next door.
Let it be another.
Instruction close.
Which, what for, what proposition?
That's it, because
What is the?
page 26, your lordship, paragraph 74, your lordship, may kindly look.
70?
74, paragraph 74. Above the question, page 26.
Just.
Whether the show cause notice. The question number 2.
No, 74 is different.
Your lordship,
Was there any willful substance of the fact?
Was there any
Intention to evade? That's true.
intention to evade?
That should be the motive of this 74.
Your lordship, that is the issue, and there, Honorable Supreme Court has said that 74 does not lie, your lordship.
No, Northern operating is very clear.
No, this is the 74. It does not talk about it. Talks about the case of a Central Excise Act.
Your lordship.
Under GST, there is no.
There's nothing.
Central Excise Act, that extended period of limitation for fraud. If there is
Understood.
fraud, that is the issue, that whether the
1
fraud
year,
is
5
there.
years.
Here also
That could not
No,
happen.
that's true. That by reason of fraud, collision, and any willful misrepresentation or suppression of the fact.
So the limitation will extend.
Absolutely.
That's why-
That is what is.
Unless there is a clear finding. to the-
So that is the willful.
Yeah, it says that Pahwa chemicals have been considered. There must be a positive act on the part of the SSP
Exactly.
within the mischief of.
Against the department, I'm saying against the department, I'm saying in favor of the department.
That is two fundamental principles that one, you say the suppression of the fact, then there must be a willful and deliberate suppression of the fact. You can't. There must be a mens rea. There must be an act.
I think your lordship thought that.
No, we are not. See, no.
No. I was just pondering that for what reason you are citing this judgment.
Exactly.
We are not against our favor. We are on law.
Question of law.
We are in favor of law.
Your lordship, yes. But that is an outstanding judgment, because they said.
If my brother dictates mind language, if I dictate so.
Your lordship, from other. Your lordship, why I'm saying so? Your lordship, because this judgment will be a great ratio, your lordship, for your lordship, many cases, your lordship. And we are trying to.
This is the place I was searching for.
I will also make certain.
Let some. Because central government, state government also the same issue. So let it be admitted.
Admit it.
We are going to. We can't allow this
Your lordship.
even for a moment to occupy the space that we will not. Absolutely. No respect for the Supreme Court judgment, no respect for the High Court judgment. What is
So way back in May 2025, you filed this petition. Till now, you are not prepared.
no?
In one of the cases, perhaps.
Why these matters are not listed when it is filed in 2025? Is a fag end of the 25 or?
No. Second,
or ultra rays and say that there is no difficulty in applying from a retrospective effect. And then say, but we find that there is some kind of a discrepancy or anomaly in the formula.
Lordship.
And then the clarificatory formula has to be worked out. Now they have worked out. So it is really a substitution or clarification of a formula, nothing. Operation is always considered to be in
Yes,
tune with the Supreme Court judgment.
yes, Lordship. Circular saying it is
No,
prospective.
Has to be.
because during that
So
incident,
why say prospective?
Lordship, there is no reason given in the circular, and that circular was challenged by assessees in various High Court, Lordship, and there are 3 High Court is decided the issue that it is retrospective, and against the Gujarat High Court, assessee went revenue went into the Supreme Court, and SLP is dismissed. Review is also dismissed.
So that's why I reacted immediately without knowing anything.
Lordship is absolutely right.
Now,
Lordship.
so what they have done, tell us.
Lordship, what has happened in my case is, Lordship, that the grounds were taken by us before the first appellate authority that it is retrospective.
True.
However, the Commissioner Appeal gives a finding that in view of the Supreme Court, Lordship,
Huh?
the
He
Commissioner
relied
Appeal,
upon the departmental circular over the Supreme Court judgment or High Court judgment.
Lordship, that time High Court judgments were not available with me. I took a ground before the first appellate authority that it is retrospective. He doesn't consider that. He says, I will go by the Supreme Court. Supreme Court said that input service is not available. Therefore, you are not entitled for 18 crore refund.
Okay.
Lordship.
Where is the order?
Lordship. Order, Lordship, is at page 11th portion, page 40. I'll just take it. It starts from, Lordship, page 37, 11th portion finding, Lordship.
Page?
37, it starts, Lordship.
No, relevant portion.
11th portion, Lordship. I'll just take, Lordships, to my submissions also before that.
No, it's
Page,
not necessary.
42.
You have already made your submission before us.
Lordship, yes.
We take it that it is there. What do you have argued? Where is the finding that?
Page 46, Lordship, finding starts. Discussion and
Relevant
finding.
portion where you have taken a retrospectivity of this, where he has said that I can't.
He has not considered, Lordship, at all. Lordship sees para 21, Lordship, 20, Lordship.
Yes, that you have raised this issue.
Raised this issue is, Lordship, is covering page 42, Lordship sees.
Please. Which paragraph?
Para 4.5, Lordship, last para, it says VKC, that is the Supreme Court, Lordship, is being pointed out anomaly in the formula.
Yes.
Next para, Lordship, para 4.6 says accordingly, GST Council reconsider the formula to rectify the anomalies highlighted by Supreme Court in tune of with the statutory provision by notification dated 5th July 22.
The formula, they have amended the formula then.
Lordship. Accordingly, Lordship, para 4.8, I said in view of the revised formula, I should be entitled for 11 crore 77 more. The table is given, Lordship.
No, they have submitted that the retrospective amendment of the rules will not create a respective liability to the interest.
they have phrased a different application.
Para 4.7, I specifically said it is
Before
retrospective.
application.
17.6.
Para 4.7, I specifically made submissions, Lordship.
Para 9 will also be cancelled.
We are at 17.0. Because that finality.
The order of the refund has attained finality.
Lordship, that finding is also there in my favor. That says that it is beyond jurisdiction, Lordship.
And then
73.
the department has not filed any appeal against that order.
Default sanctioning order was not challenged, Lordship. For that, Lordship, para 20 is the conclusion. Another ground, the appellate
Just
authority
one
says.
second.
Just 1 minute.
Please, please.
True, that's a finding in favor of the SSC. There are 20
Lordship.
and correctly reproducing the law.
Lordship.
23.0. I know that. 800.
How we jump to the conclusion is an automatic consequences. If the power of review is not there, you can't review. How can we? It will open a floodgates that after 10 years, if something is and it's a
Cases cannot
lawsuit,
be-
can't be reopened.
Because
Can't be reopened. The judgment has always a prospective effect.
yes. The closed cases
Cannot.
The pending cases, Mafatla leader and
Series of judgments. In all, I say is a jurisprudentially correct. You need not have to go for any branch. It's jurisprudentially correct.
the Tata Steel also.
Series of
Anti-tax matters.
Series
Closed
of
cases
judgments cannot be opened. Once it attains finality is a public policy of the.
Policy. Somewhere it has to stop. It should
How
not
can it
be-
be done? So consequences on the basis of the Supreme Court order. Any judgment which is rendered has always a prospective.
That part, my lord, I cannot.
So how he has done? At one go, it's a interesting the logic. At one go, in so many paragraphs, he said that there is no appeal against the order refund order passed by the authority. There is no review application which has been filed. He also says that the authority soon cannot review its order. Then he says that this order has attained finality. And thereafter, looking at the Supreme Court judgment, say consequential. Very interesting. It is an automatic consequential. It cannot be reopened, even if that order is bad. There are line judgments which says that suppose a judgment has been delivered by the apex court, laying down a principles of law and granting a relief. Or say after 7 years, another judgment, the Supreme Court has said that those principles of law laid down in that judgment is not a good law. Does it mean that the ultimate conclusion or the relief which has been granted goes? Cannot.
Every application is.
This is binding that we cannot be touched. The ratio of law will not be the correct one. But so far as the conclusion or the release which has been granted cannot be taken away, then there will not be any certainty in the law. Even 50 years back, something has been done, and then later on the court has said that this is not a good principle, and then everything whatever has been done during those 50 years, 5 decades, everything will go. Consequential, automatic consequences.
Tata Steel, I think that will, Tata Steel.
No, sir. You show us, convince me, my mind is still open. I will definitely correct myself. But this can't be.
Tata Steel and Mafatlal, 97 Supreme Court. 9 judges bench. And this Tata Steel also 9 judges bench. Anti-tax. Atiyabadi was reversed after 55 years. But their lordships have said closed cases cannot be reopened. Appealed final.
This is a closed case.
Jindal.
This is a closed case. Already the order of refund attains finality. That is a categorical finding which he has returned, saying the department has neither filed review application nor have gone for an appeal.
May I pray your option that I call it tomorrow at least, my lord, I will use.
Can't be. What?
Tomorrow, my lord, I just,
Have you not read your brief?
my lord, I have read, my lord.
So then you are ready. You know, we are reading for the, at least I can share. I'm reading here for the first time. If I can make up my mind, I believe you should.
My lord, tomorrow you will also call it.
You are so well versed with the branch of law, this branch of law.
No,
You should take even a lesser time to understand.
My lord, you will also call this matter tomorrow, my lord.
What is this? That shows that you have not read the.
My lord, I have read, but
Otherwise, you would not have asked for a time.
I'm going for tomorrow.
Department takes.
What happens?
Considered.
So let them, henceforth, I will direct that every time when you represent the department, one officer who has passed the order should stand behind you. Stand behind you, let him think. On a law point, the department will say that what is a law point? It's a pure question of law. The order which attained finality for all time to come, can it be reversed or recalled suo moto as a consequential effect? Sure, that's a pure question of law.
Yes, my lord, tomorrow is also time granted, my lord, because last night I was confronted with this brief, my lord. That is, I will, my lord, it was mentioned, my lord.
This was filed in 2025.
My lord.
Now, what perhaps he wants to say that when Gujarat High Court has quashed that circular itself, so and that assessment remained, and department did not file anything. Thereafter, Honorable Supreme Court has made some modification or clarification order.
Observe that.
Saying that
only and
18 rule 5 formula, we will not interfere with that because it is the wisdom of the GST Council to take a call. Thereafter, you have amended. So this amendment has that effect of amendment has given effect to the direction.
yes, ma'am.
So I think your authority has gone into
Will also
this.
I have read once, but I am not also clear. One chance may be given, my lord, for tomorrow, my lord. I am praying, my lord. It is a quite bulky brief, my lord, and last night I was confronted with this. This is the point.
You have not understood what I uttered. It was a bulky brief. Within 3 minutes, I could read
My
some.
lord, the acumen of your lordship cannot be compared.
No. When you find apparent, I will not go to that extent. I am very mild language. I say mistakes have been committed. That you should know.
Tomorrow, my lord.
I am not using obviously the brazen violation of the judgment and the principles of law. What to do with it? Keep it in the next week then. Same position. Consult your department on a law point also.
Item number 3.
Obliged.
On the pair.
What should be kindly take up the second matter as WPC 24993, where I filed an additional affidavit. What should be kindly-
24993.
24993, second matter, where I filed an additional affidavit.
So why you have not filed additional affidavit here?
Issues common, my lord. My refund applications have been rejected on the ground, my lord, that there's some investigation going on with a serious fraud at Calcutta.
Yes.
So the lordship would kindly see, my lord, my page 20 of the order, my lord, where the officer rejects my application. Annex 1 at page 20. Annex 1 begins at page 17. Relevant portion is page 20. Second paragraph, my lord. The serious fraud investigation officer, Ministry of Corporate Affairs, Kolkata, West Bengal, by letter number so and so, dated so and so, has intimated that an inquiry against the taxpayer has been initiated under Section 212 of the Companies Act 2013 by the direction of the Ministry of External Affairs, Government of India, wherein it has been instructed that no amount be released under any head until further notice. Accordingly, a show cause notice in form RAT 08 was issued to the taxpayer on so and so. In response to the show cause notice,
So there is already a prohibitory order which is issued that no amount should be released.
that is by the serious fraud investigation
True.
officer.
Correct.
Then, I filed an application before the authority.
So the refund application should not have been dismissed. It should have been kept in suspended animation or abeyance
2 months.
till that
And
problem is sorted out.
Annexure sits at page 52.
If nothing comes up,
Yes.
then it will revive.
Limitation under 40, this is a 54 application.
One 2 years.
2 years.
2 years.
2 years. no?
2 years.
So there is a limitation.
Unnecessary.
So whatever. If this serious fraud investigating office, if he continued for 3-4 years in investigation, then what will happen?
Your lordship would appreciate. This is a third part.
That later of corporate affairs to ask your lordship.
No, and please, Mr. Mishra, try to understand it. If there is a period of limitation provided for making an application for refund, then in that event, I understand that there is some serious allegation which has come from the Ministry of Corporate Affairs.
Yeah.
The matter is being investigated and there is already a order that there should not be any release of the money or the funds. Definitely.
Your lordship.
Then why you are rejecting an application for refund? You could have kept it in abeyance.
Not keeping abeyance, why you?
Why? Is there any mandate which is given that within a time you have to
There
dispose of?
is a mandate of 2 months. Your
That you will have to dispose of?
Sir,
lordship.
subsection 1 says,
Your lordship.
before the expiry of 2 years from the relevant date.
Your lordship.
That relevant date is explained or defined under explanation
Money.
below subsection 14,
Your lordship.
the relevant date,
Relevant.
below
And
subsection 14.
Here. 2 months period.
The relevant date, what is relevant date is
Date of deposit, date of order.
no, class B,
Date of order.
class B.
Your lordship.
In case of supply of goods, regarded as deemed exports, so
No.
this is all export
Export.
and seizure.
Sir, application. These are unutilized input tax credit or what?
This is not refund of pre-deposit.
Pre-deposit, your lordship. So fast.
There's nothing to do with.
One is applicable. One is applicable. Why I have disposed of?
No, not one. I am talking, we are just thinking about the definition of a relevant date.
Your lordship. Relevant date is.
But what we find as
That is limited to export is 0%.
I was looking at
Explanation.
the D also, the
Your Lordship, may kindly
E also, which is
for relevant date.
Sir, that relevant date relates to export and SCZ
Yeah.
0 rated.
Your Lordship.
Is it his case?
B.
the D is by virtue of a judgment and order or direction of the appellate authority or this. This is the order, there is an order for refund.
This is not after my appeal has been allowed in part. I file an application for refund of the pre-deposit minus this amount.
So that is true. So that is
There's
what,
nothing to-
so this is as a consequence of the judgment.
As a
So it comes under D.
No,
Then it comes under D.
D not if it flows from an order.
No. In case where the tax becomes refundable.
Becomes refund.
This is a consequence of the judgment. So you are saying that the appellate order has there, as a consequence of that appellate order, you are entitled to a refund.
Refund of the pre-deposit.
So this comes under D.
In any other case, the date of payment of tax. H.
No, it comes under D straight away.
Whatever.
And what is the timeline?
2 years.
2 years is the timeline. And disposal time?
Disposal time, Your Lordship, 2 months. Fine. Your Lordship, may kindly look into the provision 56. Section 56. If any tax order to be refunded under subsection 5 of section 54 to any applicant is not refunded within 60 days from the date of receipt of the application under subsection 1 of that section, interest at such rate not exceeding 6% may be specified in the notification issued by the government. And so, if I within 60 days, 61st day, I have to pay the interest, Your Lordship. For that reason, I have been compelled to disposal within that 60 days. Your Lordship.
Then there is no statutory bar. Only thing is that it will attract the interest to be imposed thereupon. That does not mean, but there are cases, and this is a case of a special nature where whether the interest should be granted or should not be granted. It is not that, again, it's a voluntary and involuntary.
If again, it will be disputed for that.
Disputed.
No.
And one of the judgments of
I'm sorry.
Mr. Mishra.
Sorry?
54(7), subsection 7, Your Lordship, may kindly look.
No, it talks about if a tax is ordered to be refunded,
No.
under subsection 5 of 54.
Sorry, the case.
No, Your Lordship, may kindly look into 54. 54(7) is there.
Mr.
Madam,
Mishra, I am reminded of one of the
Completing all respect.
No, in one of the judgments of this High Court, saying that pre-deposit does not form part of tax.
Yes.
Where is that? Division bench decision. I'm reminded of it. In 2021 or 22.
It has to be.
Sir, it is not forming part of tax.
Your Lordship,
Sir, pre-deposit is not a tax that you have argued. I think that is accepted. Now, how can you turn around? Please, that will not come within the purview of 54 at all. You have to show me a refund in that sense.
No.
Therefore, it was made through credit ledger. So you argued that
He has to take that, that is that judgment, or the Honorable Justice Muralidhar, Honorable Chief Justice Muralidhar was like. Jyoti construction.
I'm not part of that bench.
Jyoti construction unit.
I'm not part of that bench.
At that time, your lordship.
I was not.
Honorable Justice B.P. Rautra and Honorable Chief Justice Muralidhar. I had argued that, yes, in Jyoti construction. Your lordship, here, I have been compelled to dispose of.
No, I am
50%.
I'm
sorry, I have dropped.
I've already seen both.
And so, and we have no.
Difficulty is that if it continued for a longer period, then what will he do? If
Your lordship,
period expires,
Your lordship,
then he is neither here nor there, where he will stand.
Your lordship, we have no objection. We have no hindrances. Your lordship, because the central government corporate affairs will intimates and that.
I think the extraordinary and exceptional circumstances invites an extraordinary and exceptional order.
Your lordship, if your lordship will direct immediately, we will pay him.
No question of payment.
We have no issue at all.
But harassment.
Your lordship, because our hands are tied on basing on that letter only. Even we have asked 2 to 3 times to them, what is the stage of its investigation? Please intimate us. Even that is not, there is no response, Your lordship. So he also, my Lord and Senior, made him as party, that corporate affairs, Ministry of Corporate Affairs, and also submitted representation.
Where is that letter?
Your lordship, that is confidential letter. Your lordship, not kind. Also, they have applied certified copy. We have not given to them.
Certificate copy.
Because that is the internal. That is
Still you are issuing confidential
they have listened.
through e-dispatch.
The last line of the letter. Wait.
Literally 1 year has passed. What is the outcome of that particular
Your lordship.
investigation?
And
Should
also,
have been completed by now.
also, my Lord and Senior, the petitioner has requested the file in shape of additional affidavit. He has also enclosed one representation to that corporate Ministry of Corporate Affairs to intimate them their status.
You want deposit as paid deposit, and that is quantified.
That's what
You have quantified, and they have accepted. On challan, you have.
on challan.
So that was amount you are entitled to refund. You are claiming for refund.
What we are proposing is something very unique. As I said, that extraordinary and exceptional circumstances requires extraordinary and exceptional order to come. Because we find that there is a timeline within which everything is to be done. You cannot be made liable to pay the interest in terms of those provisions because it exceeds beyond 60 weeks. You are also not in a position to dispose of an application for refund within a period as provided under subsection 7. That is the situation. The difficulty is that he is claiming that whatever he has as a precondition for referring an appeal, and the appeal has gone in his favor and he is not assailing that order. He wanted that everything has been paid in terms of the appeal order. He wanted a 10% deposit to be returned. Do one thing. Don't give it to him. The order, the restraining order is that you should not release any amount of the deposit in the court. So that it will, your liability to pay the interest goes. Okay. Amount will be here. We are keeping this matter pending. Find out that what is the outcome of the investigations. If it is found that he is guilty, then amount can be reverted back to you by an order of the court. If it appears that there is no fraud which has been found and there is a clean sheet which is given, then this amount will go to the state.
Your Lordship, my lord. Your Lordship, absolutely. Your Lordship, my lord, my friend is appearing on behalf of the
Serious
sir.
fraud
No,
with
sir.
the serious fraud.
We have seen the letter.
Man,
We will not, definitely not.
no, but I'm not asking for that. No, my humble prayer will know that there should be a time limit fixed
Your Lordship,
when the
my lord.
investigation has been over.
Sorry, we can't go. That is not a subject matter here.
Your Lordship, my lord,
Neither of them will-
Then the serious fraud investigation agency is not a party.
Your Lordship is a part.
It is a part.
My lord and friend.
What are you doing?
My lord and friend, let him take instruction.
More than practically 1 year is going to elapse. What you have done? We appreciate the initiative. We are not interfering with your exercise. If it is something very serious, definitely they cannot go scot-free. But please make an investigation. If you are doing an investigation, complete within a time. Give him a copy.
I'm neither.
Come day after, I think will come on the next week. Take an instruction, and this is what we propose.
Your Lordship.
If it's
I'll be short of me as per the next.
taking into consideration the interest of all the
Your
parties
Lordship, your Lordship.
given back. You have given only one copy.
Your Lordship.
I have to copy this.
No, sorry. No, sir. No,
I'm sorry.
No.
I'm sorry.
Is a very confidential in nature. Cannot be done.
I'll serve extra copies of my learning. I've already given one to the ASG. I'll again serve the copy.
The order rejecting an application
Item number 5. Item number 6. All the connected cases.
All the connected matters. Yes, who is appearing in all the connected matters? I am.
Item number 7.
Non-constitutional of the day.
Yes.
Eight. Item number 9.
That's why I'm.
You're appearing.
He's in virtual.
Yes. Yes. Have you checked?
Is RC cancellation? Mr. Counsel, it is RC cancellation.
That's why I have not received the brief. That's why I have
It is
not received. Let's
could not come due to this bond. This is with me.
Due to strike, let's say I could not move. Let's say.
It assigned to
Next I came back.
Yeah.
Understand RC cancels.
Next.
Item number. Item number 10.
RC?
Yes, I'm.
Item 11.
Yes.
Item 12. Item number 13.
Pertains to non-constitution of JSQ. Sub-item is, the second sub-item is also a non.
Item number 14.
Mutual fund distributor.
Yes.
Mutual fund distributor.
Mutual fund. Achha, mutual fund distributor.
We
Distributor or agent.
distribute. We attach lots like investment mutual funds. And the investment which you make, the distributor gets some commission. And that commission is exigible to GST.
No. What is the modus operandi of the business?
Modus operandi
Distributor means the mutual fund distributors means what? What is their
agency code.
correct?
Yes.
So they have been given an agency code
Correct.
by all the mutual fund those who are companies. Correct.
The agency code belongs to they give me under that if I
So
invest
say the mutual fund agent.
agencies.
Distributor that was
That they talk which I don't know. They talk which belong distributor. We call it agent.
Item note 17.
When is the matter being before the Supreme Court?
27 I think 29. This 27.
Item notes 18.
1814 is to cancellation of GST. Sorry, cancellation registration. Sub item is also cancellation.
Item 19.
RC cancellation.
Item note 20. One.
What? I could not hear.
Sorry.
Covered by your.
Which one?
21 or 20 what?
Item 14.
20 in this case, it's a service tax matter and that it is remanded
The 19
assessment of such. It is better for us if the assessment is being done. So,
Yeah.
has been passed by the Supreme Court.
You are agreeing to that? Yeah.
Yes.
Item note 21.
This cancellation is both.
Item note 22.
My lord, in this case, the address case not got communicated by the object to the case law. Now the same was solved of the case.
Minors are there.
I have filed the certificate copy of peace of bed. And has not supplied to the.
What are you doing?
Minors that is there. Minors will also allow it there. Minors will give certified copy. They have applied minors. There is to give the certified copy. We will give them.
Limitation?
Madam?
Limitation?
Limitation is there.
What is the date of the order?
And
Will it start reading from the date when the certificate copy is made available or from the date of the order of communication?
Within, I think within 7 days, from filing the appeal, they have to furnish the certified copy.
Have they filed the appeal?
no.
Because no order was given.
No order received.
What the
No order is given.
certified minors they could not file.
No,
Minors.
even copy, normally, a copy
Yes,
is
madam.
uploaded to enable him to file appeal
Yes, sir.
within time. And within 7 days from filing, he is to
Give the
publish the certified copy. So that is a mandatory or directive, let us note that. But no order is coming.
It will be given minor within.
That means it is not prepared. That itself indicates it is not at all prepared.
We are keeping this matter, which place?
Bhubaneswar 2.
Bhubaneswar 2.
Correct. We are keeping this matter tomorrow, bring the entire file of the case. A serious allegation is made in the instant.
Item 23.
Top point in this case, is pursuant to amnesty scheme, and call it an amnesty scheme. for the period 17, 18, 18, 19, and 1920, there was a procedure prescribed under 128 capital A, where if I pay up the taxes, interest and penalty will not be levied. In the present case, which involves assessment years 18, 19, 19, 20, I paid up my taxes, and ultimately a series of SPL forms were issued, and finally SPL 05, which culminates final order by the proper officer, that was passed. And
Status is given.
pardon?
Status is given
One,
to your assessment period.
for that assessment period, and SPL 05 was issued. Thereafter, my lords, the department, my lord, they have now filed an appeal challenging the order in original. Pursuant to the
Once the amnesty scheme has been floated and the person has taken advantage of the amnesty scheme,
one,
then how the order merges with the same? How can an appeal be filed?
The Lordship, in this case, in page number 232, they have applied for the insertion.
Waiver of the interest and penalty, that's the amnesty scheme if they pay.
But in this case, the Lordship, Annexure 6, the order is passed now on 12/6/2025. Against that order, the department has filed an error. That order was passed under section 73 and this is under section 74.
the scheme, my lord, was for 73 orders.
And
I
this
think-
the appeal which is
I think the scheme has to be looked into. If the scheme says that any order which is passed under section 73,
will be allowed.
that will be allowed for a particular period. So there must be an order. And if the order is there and they have undergone with this amnesty scheme, and ultimately order is passed by an authority under that scheme, what is the occasion for challenging the order?
Lordship, in this case, 7%, the order which is, the scheme which he has availed, that was for the period for the period 17-18 and 18-19, and the order was passed under section 73.
True.
Now, in our case, in this
It is for a subsequent year.
in this case, that was passed by the state GST authority, where they availed the scheme.
It was by the central authority for 18, 19, 19, 20,
Now-
not 17, 18. It's
Now-
18, 19, 19, 20.
Now, we have
And that
passed
is
an
ordered in original at Annexure 6 series, beginning on page 158.
This order is
31.
This order is will pass on 12/6/2025. My order, which they are challenging and they are putting an appeal, that is an annexure.
Not an order, no, it's an appeal which has been filed by Annexure 9, dated 10/12/2025. After obtaining the order of the commissioner. If the lordship will kindly turn to Annexure 9, Lord, page 267. Page 267. Lord.
This is before the commissioner appeal.
Before the commissioner appeals on the recommendation after a review, my lords, this particular appeal is now been filed before the commissioner.
Review authority, did they consider that there was already an order was there under amnesty?
Nothing.
Review whether to file appeal or not. The commissioner did not have the occasion to look into that. Has he recorded?
He has not recorded. He has not recorded because I only have this appeal, which is filed. A copy of the appeal is sent to me. I am not privy to the review order now.
Of course, you are not privy, but he decides.
He has to decide.
Decides. The review means he decides whether to file appeal or not.
And if the lordship would appreciate, sales tax also Bhubaneswar Lord, he issues me a certificate at PL 05. The commissioner at Bhubaneswar, Joint Commissioner at Bhubaneswar instructed.
This order is passed, which I am looking at page 308, is under section 74.
309.
308. I'm talking about 308, operating portion. As also evident that the notice is liable to pay the GST of 31 and something for a period 1718 to 1920 under section 74. It's not under section 73.
73, my lord, has given the height because after this
Amnesty is only applicable to
73, my lord. Only the
For
penalty.
the same period, 74 was initiated thereafter. Thereafter.
Thereafter.
On a different note or on the same fact?
Same fact.
How can it be? Once the 73 is invoked, there is
Same
no
fact.
fraudulent intention. There is no fraudulent intention to evade the tax. Then after that adjudication, how 74 fall back? It may, if there is something more,
Something more.
something more, which would not be ascertained in 73 proceedings. But you are saying is on the same thing, then it's a very difficult
Your
one.
lordship would appreciate the period. It's 1890.
No, 7. I find from 308 is 1718 to 1920.
The lordship will kindly turn to my lord, page 292. The brief facts of the case. Period is 1892. Sorry, 292.
Yes.
1819 and 1920.
1920. Which is the period which was already assessed under 73.
True.
And it was, my lord.
Then order why it includes 1718 as well?
1718 is not covered, but I have not gone for 1718.
No. Then why the order covers? Because if it is only relation to 1819 and 1920.
The lordship would appreciate page 292.
I am appreciating Roman 1.
Roman 1.
We have not paid or a short paid of GST for a period from financial year 1819 and 1920. If you come, this is the part of this order of 308. This is the part because that was the subject matter of challenge. Then how in a concluding portion he has included 1718 as well?
There's no, that can't be known because this was initiated.
That is what we feel about 308.
Where is the notice for this?
And it should 10 your lordship.
You should have.
And it should 10 your lord that 309.
Age?
Not like this.
Age?
309.
That is the notice for hearing before the first appeal.
No, where is a show cause before initiating 74?
Nothing.
A notice must have been given.
What has happened, my lord, in this case, there was a 74 order. It was nothing has been done. Then a 73 order is passed for the same period. For which, my lords, I, my lord, go in for this amnesty scheme and SPL 05.
No, I understand, but I am still under.
This scheme, whether the contexts
Context
of
is the same.
73 and 74,
Are the same.
that is why we want to see the notice. I think notice.
That is what I was just thinking about it.
So both the
And the
notices.
second alarming one is.
Notice at 74 notice, kindly.
And second alarming is that when the adjudication is restricted to the financial year 1819 and 1920, how can we pass an order for 1718 as well?
Only the exception for notice data.
That is what.
Notice is that
Your lordship will kindly see the sequence. And thank you. The original show cause notice under annexure 1 was under 74. That's page 19 to 60.
Page
19 to 68.
Is 19, it starts. So July 2017 to March 2021.
20, yes, tax period,
That's a tax period.
That is under section.
74.
74. Then
Yes.
not this particular.
This is there at the last 74 one.
In annexure 2 below.
Yes,
Under this order in original was passed in, under annexure 2 under
Page.
section 74.
Page.
69 to 125. And at page 125,
just one minute, let us. Where is the concluding portion?
concluding portion begins at page 123.
So this was the 17, 18 was deleted.
Deleted only 18, 19, 19, 20 and
20 was the only confirmation.
only penalty was involved.
Yes.
And italic 4.
Well, demand of GST under RCM amounting to be so and so is
Oh,
dropped.
pertaining is dropped.
Is dropped.
So it will drop.
Drop. And I
No
impose a
difficulty.
penalty of 1 crore amount.
True.
Then it was only a penalty which was levied. Against this order, my lord, I prefer an appeal.
True. 74.
In the appeal, he converts the proceeding into a 73 proceeding.
Where?
My lord, this was confirmed. Then I came to the High Court, my lord, and copy of the High Court at Annexure 5 at page 152.
What?
152, my lord.
Yes.
This is the order, my lord, is the Honorable Court, my lord. 156, my lord, it begins. This is so and so learned at
So say restoring the proceedings after setting aside the order,
Manus.
certificate copy. So it does not talk about anything.
74 was set aside.
That's all. Then
Then, my lords, the 6th series was passed. Or order in original was passed under 73 minutes.
where is that?
No, there's 158.
150. Where is the concluding portion?
Concluding portion, my lord, is at 231.
221.
230, 29. I'm sorry, that's 10.
It's 229.
I confirm the demand so and so.
Under section 31, 37, 33, 73, 9.
739. So 74 now is converted to 73.9.
True.
And against this, my lord, I prefer, my lords, this amnesty scheme. And, my lord, is at page 243 for 1819. This is for 1819.
GST SPL.
Months. SPL 5 was issued for 1819, and then at page 250 for 1920, this SPL 05 was issued. So it covers both the periods.
So now, thereafter what happened?
But thereafter, my lord, what has happened? Now they have not challenged this by way of an appeal. The
Which one?
original
Of the appellate authority converting into a 73.
That
You have challenged.
original order was passed, only levying penalty under 739. So that particular order ended in my
That's-
SPL 05.
That is the original order in appellate. Forum.
Or after that, my lords, it was an original order because after the remand of this honorable court, an original order was passed.
Okay.
So in that original order, 73
9 was
only penalty done.
no difficulty.
My lord, I preferred this amnesty scheme.
So now preferred and you got the relief
I
from
got the
there.
relief.
Now
Then
you have challenged this
the
order.
order in original.
Order in original means
Annexure
converting a 74 proceeding into 73.
73.
So they have challenged it.
That challenge it. 23, 6, 2025, my lord.
Yes. So what is the
that challenge.
difficulty?
The difficulty, my lord, is that once this culminates, this original order no more survives. My lord. After having issued, my lord, SPL 05, the entire issue, my lord, is set at rest.
Ah,
And again, they converted it to 70.
See the subject.
When that order 73-9 was, that is what page?
73.9, my lord, would be at page 229.
Who?
229.
When that order was passed?
That order was passed, my lord,
12/6/2020.
Zone 25.
23, 6, 2025.
Huh?
No,
12/6/2025.
12th June.
June
12th
2025 on the top. 12th June. So they have filed an appeal or going to file an appeal?
They have already filed an appeal. Your Lordship.
When?
Lord, they filed an appeal on 10/12/2025, Annexure 9.
They have 180 days.
They have 180 days, 6 months,
State has
Well,
180 days.
180 days,
Plus,
And
plus
when
1
they-
month,
plus 30.
plus 130.
So
We have 3 plus 1.
150 days.
No. 180.
180 acha, plus 30, 210 days.
10 days. But we get only 90 days.
6 months or 180?
6 months and 1 month.
Plus 1.
Plus 1 month. We get 3 months plus 1 month. And if your Lordship would see the subject at Annexure 9, page 67, 267. It says filing of departmental appeal against order and original number so and so, dated 12/6/2025.
Page?
267.
And when the SRL 5 was issued,
Well, that was 3110 millions. Your Lordship would appreciate.
31?
3110 millions.
Yes, 3110.
3110.
And appeal was filed thereafter.
Appeal was filed thereafter.
So
one is 3110.
they did not make any submissions that we wanted to challenge that order before the amnesty scheme.
That was accepted.
They did not say anything that we are going to file an appeal.
No.
Because appeal came in December.
And this was not the final order was passed on October. The last.
I've seen that 31st October.
30th of October 2025.
I find 31st date. Aishwarya Misra, that is the 31st date. Acha, digitally signed, yes. That is on 31st 10.
31st 10.
Is 270.
And for the other year,
That's
3010.
That's right. Page 270. That is total which is necessary. The column serial number 5. Serial number 5.
Oh.
Not paid, short paid, not paid, short paid.
What to do? Because the consequence of this order is.
Today, no more. We have many. No.
No. I'm just pondering about the right of appeal is there. One can, with an exercise that I can. How many
time limit and disposal also there is a time.
What is the time limit for filing?
Of appeal.
The
Amnesty scheme.
30th June.
From 12th June,
30th June 2022.
that is 128A.
128.
what is the period of limitation provided for making an application under the amnesty scheme?
30th June 2020. 30th June was an instruction. 30th June 2020.
30th June.
30th June.
And what is the period within which the application has to be disposed of?
You said thereafter.
Hmm?
I can file appeal under subsection 3.
Oh, okay. The Lordship, can we come to the circular?
Any order is amenable to appeal under subsection 1 of 107. For department, any other provision?
The CBIC circulars, they will not have annexed at page.
In statute
The statute
107.
107, one is for the SSC, 1072 is for department.
Acha.
But
So 128A that confines only to subsection 1.
Does it restrict to a SSC?
it restricts both to the SSC as well as the
True. That is what, because it talks about any person aggrieved.
any person.
So it is a much wider one. And it says that who is aggrieved by a decision and order passed under this act, or the state, whatever.
The same time, CBIC circular is also there.
The commissioner may, on his own motion or upon the request from the commissioner, call for an examine. This is what is the as a revision power. Review or a revision power.
It is 118, not an appellate power.
6 months. Will file appeal. They will instruct, the commissioner will instruct the joint commissioner to file appeal.
And the CBIC circular law restores.
No, I understand. One has to, because the provision, there is a distinction between a period of limitation provided for an appeal and a right to appeal.
Mm.
The right to appeal must emanate from the statutory provision. Unless the statute provides, nobody can assume that I have a right to appeal. Correct. Subsection 1 of section 107 is the provision relating to right to appeal. Subsection 2 gives a power that somebody may think to file an appeal under subsection 1, and the period of limitation for invoking or filing an appeal under subsection 1 is also provided. So this is nothing to do with the right to appeal. It is a decision to come to a conclusion that I am a person or a department is a person aggrieved. So appeal would lie under subsection 1. That's the right to appeal. Why?
This is very interesting.
It's from there. It simply says, by order, direct any officer to apply to the appellate authority within 6 months. So that's a period of limitation is something different. Right to appeal is something else. That's a substantive statutory right. It's true. That's true. There may be a different period of limitations, but right to appeal must emanate from the statutory provision. Subsection 2 talks about direction to apply for before the appellate authority, means invoke the right to appeal, and the period is different. One is for 3, one is for 6. That is always there.
Section 3 is example 2.
That is in subsection 1.
That's procedure.
That's the procedural part. And then you were saying section 100?
128A, 149 page.
Rule 164.
Mr. Karan, come to section 128A, subsection 4.
Notwithstanding anything contained in this act, where any amount specified under subsection 1 has been paid and the proceeding are deemed to be concluded under the said subsection, no appeal under subsection 1 of section 107.
That's all. You stop here.
It's
Would like.
applied. And in this
This
line,
is what I was thinking aloud, that what would be the effect?
give us a- and that was clarified by the CBIC that no appeal lies.
We go by the section. Go by the section. So in that event, Mr. Kedia, how a thing would like? You have filed an appeal later on. It is not earlier.
Lordship, if you see SPL 2, the date of order in this
Is 12/6.
is 23/6/2025. And here the appeal, the order which has been passed is 12/6/2025.
Sir, please kindly try to understand. Sir, he has invoked the provision of the amnesty scheme in terms of the order passed on 12/6/2025. Because you may have initiated a proceeding under section 74, but ultimately when the matter is remanded by this court for fresh hearing, your authority, suo motu, converted the proceeding from 74 to 73 and passed an order. That means the authority did not find any willful, fraudulent intention to evade. You are aggrieved that how can you convert it into 73? It should have, once it is initiated under 74, there is no power which is given to our authority to convert it into 73 or whatever is the reason. You may be aggrieved by that. But the difficulty is that before you could take a decision, because you are still within the period of limitation, he has already approached the authority under the amnesty scheme, section 128A. 128A provides for waiver, and then in subsection 1, the waiver has been allowed or the application has been allowed, treating the 73 because it is restricted to 73. Then in that event, why not subsection 4 will create an obstacle to you in filing an appeal subsequently? It has a overriding effect when a non-obstante clause is used. That means it overrides the other provisions. So no, we are or subsection 1 or 112. We are not concerned.
That is,
We are concerned with subsection 1,
this.
subsection 1 and section 7. That's all.
1071.
There is no other specific provision for a department to file an appeal. It's the same provision. How can appeal lie?
This contention may be taken by them. The notice has been issued to appear before the appellate authority on 10/2/2026.
Sir, it is striking at the root that the appeal itself is barred.
Let me take instruction, Your Lordship.
What instruction?
And I get the details of it.
Mr. Court did not notice this.
I'm sorry, I did not know this.
I
Came from your lordship.
90%, CBSE.
No, that is in section 8, my lord. And
Yes,
section 252.
Your Lordship.
252.
252. It begins at 252. Relevant portion is 258, which has echoed your lordship's observation. No appeal.
Paragraph.
Paragraph 3.4. 3.14.
1.4.
3.4.1. No appeal shall lie under section 107 against an order issued in form DST SPL 05, concluding the proceeding under section 128.
No, that is in relation to SPRL 5.
Man.
That order is not appellable one.
Man.
But that is not a case here. Here is the appeal under section 107. Whether it is barred.
No, that is explicitly barred because you give the quietness the interest penalty.
No,
Thereafter, you make up an issue.
that I understand that you bring the quitus to the whatever the order which is there. I understand. That is what I was just thinking of this provision. So difficult situation.
128A has a rule.
164. Rule 164. Team A may be relevant fields. Obviously, team A. And what you could kindly come to this paragraph 3.2.2, clarifying the issue at page 258. Okay, what you could kindly see more. 3.4.2. It is also important to note that the subject matter of appeal will not be regarding the applicability of waiver of or interest or both under section 128 and not on the merits of the original notice, statement or order. So this original notice, statement or order is also not applicable. All that you can do is you may question the issuance of 07 or whatever, but not the original order. No, that doesn't spring back to life after issuance of SPL 05. So the purport melodis,
Anything touching the
merits cannot be
during that period in question. That is given.
Quite that's why the CBIC has clarified that and not on merits of the original notice, statement or order. So that this OIO does not survive anymore to be agitated in an appeal.
You mean to say that section 74 order does not survive at all when it is converted to 73 and STST?
All that it could have done, they could have challenged the SPL 07. 07 order can be challenged because that is also the CBIC's thing. But no, it says that and not on merits of the original notice, statement or order. That's paragraph 3.4.2 at page 258. Which is a part of the CBIC circular. The quantification can be appealed against.
So 120A covers 17, 18, 18.
Yes.
18, 19 and 19.
From 1st July 2017 to 31st March 2020.
No, that was the original scheme. No? So far as the petition is
That is
concerned,
initial 3 years.
initially it's 17, 18,
Excluding one quarter.
the 17, 18, 18, 19, 19, 20 was a combined order. For 17, 18 was done under 73. For 18, 19, 19, 20 it was done under 74. That was the subject matter of challenge before this honorable court. After this remand, my lord, to the original authority, he also, my lord, carries out an assessment for 18, 19, 19, 20 under 73. The argument was, my lord, if it is a block period for the same issue, you can't segregate one for 73 and two for 74. And after the remand, my lord, he has now assessed me under 73 for the period 18, 19, 19, 20, for which I've gone in for this scheme. I paid up my taxes and the penalty and interest was waived. And finally, this order, this closure under the SPL 05 was issued. And the CPIC circular says that the merits of the original order, the statement or the notice cannot be challenged after issuance of it. All that they could have done is the quantification of this SPL 05, 07, and that can only be challenged. That is the purport of 3.4.3. That if anything extra is found out, I have to pay up that amount. So that is, my lord, the subject matter of appeal, maybe a subject matter of appeal, my lord, but not the original one. Acceptance is 05 and rejection is 07. The rejection can be challenged.
120 days very well answered. No,
What?
at 120 days very well answered, both for the department as well as for the assessor.
What?
So far as this issue department has to lose, and also in some cases petitioner has to lose.
Lose.
That should be.
Consequences is there. What I believe is,
deposited, they cannot claim refund.
you can't thereafter take a decision and go.
Amnesty is given to one of us.
Sorry,
Once you consider him to be
I get-
one of us,
we don't think so.
how can you
No.
now say that it is fraud?
And as per 75
Get
two,
some more clarification.
Work.
section 75 two, the conversion is valid. As per section 75 two, the conversion is valid from 74 to 73.
No, I am not entering into those aspects, whether that was justified or or can be done. The question is the absolute prohibition of preferring an appeal.
Yeah.
If there is a prohibition of preferring an appeal, how can you make and file an appeal? It strikes at the root. Adjudication, what he will do? If he cannot touch and the appeal does not lie, then what remains?
Will verify the commissioner will have to review that order 73. We may convert it to 74.
That was there, sir. Why you proceeded so hurriedly under 128A? Before you file an appeal, you could have filed an appeal immediately. And there is a provision that says is the pending that it will not apply 128(1).
Let me take.
Then it will not apply.
7 days, Your Lordship. I'll take instruction and
You could have very well avoided that, but you have not.
I'll be taking it. 7 days, Your Lordship.
And any instruction you take against this circular, this instruction,
I'll be putting that circular to them. I push that circular to the department and I take it instruction. What will be the fate?
Really? Bring those line of judgments. There are catena of judgments which says that a right to appeal is a substantive and a statutory right, and how the appeal has to be filed. This is what a procedural part. So, procedural part cannot eclipse the substantive right of an appeal. You also find out the judgment. I will interpret subsection 2 of section 107
This will be.
with the subsection 1 of 107. I will make the convergence in between them or a linkage in between them. What does it mean?
In Mr. next case is
Your Lordship, item 73 4B, I am for the petition. All the
23.
three matters.
Item 24.
73.
Which one?
Item 25.
25.
24. 73. 73.
All sub-item?
Your Lordship.
25 also 73 for the.
73.
Yes, miss.
Item 47, my lord, may be taken up Thursday, next Thursday. Item 47.
You have to just make a workout, a distinction. And then,
Not like this. Events chart. I think the piece in quota set aside, quota convert, quota.
The sequence will be given to you. Yeah,
So that clear picture.
let us see, sir. We are moving fast today. Yes.
This will be left to one item, sir.
1 week,
Any matters which you have filed your counter? Because there are hundreds of matters of 180 ml. In any one matter, have you filed your counter? So that we can take that matter and decide all those matters at one go, sir. That is what I am requesting since last 3 months. I think it has gone to a deaf ears. Not even a single matter the counter has come. If you are
and this matter.
give it peremptory. Otherwise, we'll decide in their absence, ex parte.
Seven Mallots tends to the same issue regarding limitation. So judgment. Mallots have taken 36 sub-item. 36 sub-item 2 Mallots, that was the lead matter also are considered. Sub-item 2 of 36.
That has already been argued. So give us some breathing time to.
Because I'm handing over a brief note of submission.
Yes.
You have the department. I had already handed over Mallots a list of the high courts.
Just visit.
Tendering numbers.
I'm also giving my. Giving you one pager. This is my written note number 5. There are 2 doctrines which I say of some benefit of this court not on the doctrine of inversion and ABC test, which of course, if not, I have argued. And
The doctrine of inversion, my lord, this is, your lordships know that a Wambach test that is generally used for the purpose of distinguishing, my lord, the ratio decidendi and the obiter dicta. But what I have, my lord, framed up this doctrine is in the context of the state arrogating a power of review in the space of a judicial review, my lord. Yet it says that it is a matter of right. It is a substantive right. So in that scale, my lord, I have given that doctrine of inversion. And the test of ABC, my lord, your lordships have already argued that once an argument is happened on ABC, then EFGH can be a subject of judicial review.
So the previous occasion, my lords, will also permit. Previous occasion, I had cited two judgments. My lords, one of the recent judgment, Rikhabchan Jail of the Honorable Supreme Court, but they referred to 1961 Supreme Court of Wadhwani judgment, my lords. When they have referred to one principle that if a party, my lord, this is not a case where the party was remediless. Party always had the remedy, did not avail the remedy, and he has chosen by disabling his rights.
Because we are really grappling with one situation.
Lordship.
Situation is the absolute, I would say, the prohibition having created in entertaining the writ petition. If the normal period of limitation for an appeal has already lapsed, so whether it can be a better in that way. We are just thinking in that way, nothing more than that. If it is entertainable, depending upon the facts of the case, whether the court should exercise the discretion, not to exercise the discretion is one thing. That leaves and depends upon the court to court and a case to a case and a facts of one case to a facts of another case. That is what is. We are on a very more primitive point.
Indeed, my lord. When there cannot be an absolute fit on the constitutional power of this honorable court.
No.
My lord,
Approaching is one, entertainability is another.
Indeed, my lord.
You know, approach cannot be curved. Approach cannot be curved, but the approach cannot be excluded, nor the doors can be closed. We are conscious, there is no difficulty. From Keshwar and Bharti to the Alchandra Kumar and all series of judgments, we are quite oblivious or not
conscious,
unoblivion of those.
Well, so just give us
but still, we have to consider upon the issue. One observation in paragraph 23 or 24 of the Glaxo plea.
23. 19 is the negative, 23 is the
1961 judgment. That was a case of wrong. This is a very interesting one. They say that there was a case of wrong classification of a particular entry. That was a gold-plated nix that was imported, and department wanted to classify it as gold, and they wanted to levy a tax of 78.34%, my lords. And the assessee was claiming it should be 30%. The High Court said that it was manifestly unjust. Well, in those cases, my lords, I'm arguing against myself. In those cases when it's manifestly arbitrary, manifestly unjust, then it's face on the face of the record itself, my lords. It's an error of jurisdiction. In those cases, the lordships have ample powers to interfere. It's a case of violation of fundamental rights. This court can't shut it down to the litigant.
We are conscious of Whirlpool principle.
Indeed, my lords, absolutely.
Golden principles are there. We are conscious. There is no difficulty.
In fact, that principle, my lords, the majority judgment, paragraph 7 of Wadhwani, they have referred to these aspects, but they have also said that if party has disabled himself by sleeping over his rights, then in that case he can't come and knock on the doors of this court. And that has been followed, my lords, in Rikhabchan Jail recently. They've said that a party which had an appeal provision before the High Court under the Customs Act, instead of that they preferred writ petition. High Court said, and after the time period prescribed in the statute, High Court referring to 1961 Supreme Court said that he could not have done that. That is the essence, my lords, of that recent judgment of 2025 authored by Justice Dutta. On the merits, my lords, this is a case, my lords, the petitioner, my lords, is not a...
Last, this the land acquisition case one case also.
Yes,
SB Global. Now it has come in February.
And section 5.
And the provision may not be in SB Global's case is parametered to 125 for Indian Real Estate Act, which has been dealt in ONGC's case.
And
so that will throw much light to my lord.
They have not considered the act.
This time construction, I think Justice that is also, unless it is expressive excluded, that is construction.
Singh Enterprises and Hongo, my lords,
HON'BLE on a different,
Seeing enterprises, that is
seeing
not.
enterprises, I've seen that is on a very broader bill space. There cannot be any difficulty in this regard.
In fact, Flexo is a continuation of those principles.
No, sir, that is what, it has gone a bit
Further because it fetters the power of
that is what is the trouble, which really faced by the High Court. So that is why we have to just consider in that perspective.
Because of the ONGC and 32, 142 article.
Yes, so far as the civil proceedings are concerned, there is a express period of limitation which is provided. Even if there is not an express period of limitation which is provided, then the residuary clause, both for the suit and the applications, are also applicable in this regard. So far as the rich courts are concerned, can there be any kind of a curtailment, abridgment to invoke those particular remedies or a remedial measures which is provided by the Constitution? So that is what we were thinking about it. That's why the court has made a distinction. Maintainability and entertainability. Maintainability is one aspect which strikes at the root of the jurisdiction exercised by the court. And the entertainability is the discretion, which the court, depending upon the facts of each case, whether he will entertain or grant a relief or will not grant a relief. These are the wide distinctions which we are conscious about. There is no difficulty in that regard. When the entertainability is somehow interfered with, or may use tinkered with, then one has to ponder upon.
That's so almost we have two.
The state. I understand.
I'm applying for the center. Item 33. Item 33.
People order in that this 10 annex 1. My submission for options is principle of natural justice are not followed. You'll also get it as 13 votes.
As
4.3.
Because Lordship may remember this matter matters. This matter was kept because of the impure order which has been challenged is dated 38 2024.
And challenge is coming
Start 4.3 at page 13.
after 1 year.
In that right.
10, 12.
Page 13. 4.3.
1.5 years. 10, 12, 2024.
I more points.
More than 1 year, 3 months of the performance.
I have not been hard notes. I find that in spite of issuing so much notice, the notice has not required to the office.
What is the head of this? Have you got an appeal?
No,
There is a,
no.
had you preferred an appeal?
No, I have not put it down.
He's starting with the word, had you preferred an appeal.
No, I have not put it down.
I have not completed that sentence there. I'm just continuing with that.
He has not asked, have you preferred an appeal? He started with the sentence, had you preferred an appeal, then he wanted to say something.
107.4, there is a out of cap. Having not preferred this within that period, can we entertain?
Yes, if principle of natural justice are not followed, then in this case,
You have not watched the proceeding which was going on with battery of lawyers, Mr. Jagwant Sav, Ms. Kazal, Mr. Prasanjit, Mr. Biswajit.
they are all tax masters to us.
So that was the question. There arose, that was the question.
They are all taxpayers. I'm
Sir, 1071 speaks in 3 months specified period. 4 says discretion of the authority 1 month.
Independent and to be dissected from one from the other without the reason being. That's it also.
The incident of tax may be different for different reasons.
And section 2106, the definition of tax period also other courts are also referred to, saying that that's one thing to bear in mind. The due date for filing annual return is the basis for completion of adjudication under section 73 or 74 as the case may be. Because 73, 74 always refers to minutes.
Where are those compilation of the judgment?
Yes, sir. I'm giving a prepared.
Have you gone through?
No, his copy has not been served.
And I have also given relevant paragraphs also of all these judgments.
Yes, what you say? This is close down these judgments. This is very according to him, all the high courts have taken a uniform view.
One more thing also, let me add, subject to my Lord's kind permission. What inherent difficulty does that happen if consolidated assessment is taken up? Yes. The scheme of law is such, perhaps the provision is such that provides, if before issue of show cause notice, I pay the entire tax demand, because that is initially it proceeds with integration liability. That's once liability is computed, it's quantified. If I pay the demand, tax before a formal show cause notice issued to me, then in case of 73, no penalty, only tax is paid along with the interest, and the entire proceeding will abate. That will put an end. But it's a curtain withdrawal, no further proceeding. Second, in case of section 74 in the same manner, if I pay the entire tax, and the proceeding will culminate upon payment of 15% penalty and interest. So that will give me entire liability. I need not pay the interest, pay a 100% penalty. I need not pay any other consumer proceedings. So those benefits which emanates from the statutory provisions at 74, waiving the demand of interest and penalty. But those are done away with if I pay the amount and if there is independent assessment by bisecting each and every financial turnover and adjudication taken up independently. That is why the Lordship have said that you cannot clock it, you cannot consolidate all the periods, which also goes with the very spirit of the different statutory provisions, like 73, 74, and also so this is the basic.
There are some judgments which are in favor of the department also. I will brought to your Lordship knowledge. Short.
Next week we are keeping, we want to disclose, there are many matters which are really grappling on the docket. This traveling on a docket, many matters are there.
And recent judgment in Delhi High Court, Honorable Delhi High Court referred Bombay High Court, Honorable Bombay High Court referred to all judgment grounds. So that is why I said,
So
the last judgment.
the matters, this is the tag matter. Who is appearing?
Section 2 is also the tax matter.
No, there is only one sub-item.
Yes.
Lordships, I'm for the tagged matter, Lordships, and virtual court.
Yes.
Lordships, I'm for the
So he is asking for a time. Are you adopting the argument of Mr.
I'm adopting your Lordships. We have prepared a combined compilation of Lordships.
Yes, so he wanted, the other side wanted to go through that judgments, and for that we are keeping this in the next week. Yes, keep this matter in the next week. Go through that judgments. Sound has completed his argument and submitted the compilation of the judgments, which judgment taking a uniform view that clubbing of multiple financial it will take only half an hour. Find out. Come in the next week. No, 2 weeks.
Let's get to 2 p.m.
49.
Is it central or you are central GST? No difficulty. Happy note has come. Recent. Implemented or not?
Yet to.
Yes. Next.
Item 49.
Recent.